Okay, you're good to go.
All right. Hello, everybody. Greetings on this windy day today. I'm calling this meeting to order of the College Place Diversity and Inclusion Advisory Board. Will the clerk take roll call and verify we have a quorum?
Yes. Member Sullivan has requested to be excused. Member Pike?
Here.
Member Lopez?
Present.
Chair Steckline is present.
Here.
Member Pons is not here. And Member Hernandez?
Present.
Okay. We do have 4 committee members, so we do have a quorum. We also have with us City Administrator Rizzatello, Police Chief Tamaris, HR Manager Doring, City Attorney Ree Colwell. I would like to introduce you to Sherry St. Clair. She is our new Deputy City Clerk. Ree, you can't have her. Deputy City Clerk and Events Coordinator. And so today is her first day, so she gets a meeting right off the bat. And
Wonderful.
Here.
Who was the last one you mentioned?
Mayor Hernandez.
Mayor Hernandez. Oh, okay, perfect. I'm on my phone. Sorry, I'm swiping through. Good to see everybody here. So the first thing we like to do here for our Diversity Inclusion Advisory Board is acknowledge the land that we are on. So we want to respectfully acknowledge that we are on the traditional land of the Confederated Tribes of the Umatilla Indian Reservation, including the Cayuse, Walla Walla, and Umatilla people. Their stewardship of the land over generations is based on their belief that water was created first, life and land were created next, and land promised to take care of all life. All life promised to take care of the land. I attest, affirm, and acknowledge our responsibility to care for the land, the natural resources, and all people benefiting from their hard work. We come together in the spirit of honoring their legacy. It's now time for our consent agenda. So today our consent agenda has the agenda for the November 15th meeting, which is tonight, and then the minutes from our last meeting, which is May 17th, 2021 was the last time we met as a board. And I believe everybody received a copy of those. So are there any corrections to the agenda or minutes? I don't hear any. If there are no corrections to the agenda or minutes, is there a motion someone would like to make?
Motion to accept.
Okay, there's a first. Would anybody second that motion?
Kaylin Pike, I will second.
Okay, thank you. There's a first and a second. All in favor, say aye.
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 All opposed, say nay. Okay, motion carries. Okay, is this right? Presentations, we have no presentations today. Okay, and then action items. So the first action item for us today is the beginning to review the wording of a proclamation for Native American Heritage Month. So November is designated as Native American Heritage Month. And so there is a proclamation that has been put forth. Oh, perfect, we brought that up. So if we can all take a look at it.
And I have a clarifying question on this document.
Yes, Keely?
Did we consult any First Peoples in the creation of this document?
That's a question for city administrators. Did we consult with anybody in our local area or just in general who associates or who is
You're muted,
identified?
Mike.
Oh,
Getting stuck there. Is in general, not specifically. We could do further outreach. Lisa, has there been any addition on your side or?
No.
Okay.
do you have folks that you can reach out to? Do you have those connections or contacts, I should say?
I do have the contact information for the executive director with the Confederated Tribes of Umatilla.
Does that answer your question, Kaylin?
Yeah, I guess I would like to make a motion then. It looks fine to me, but I'm also not the one that this is directly benefiting. So I would like a motion that before this is posted, that Mike, you are able to talk to someone that is from the Umatilla tribe to get their approval.
Is there a second for that motion? If you could unmute and say it, that would be very helpful. If anybody is inclined to second that, we do consult with the Confederate Tribes folks before it's posted.
I just have a question, Nadine. Does that mean that it would be delayed till next meeting, or does that, if there was a change, how does that happen? Because I'm not sure that I understand that process.
That's a good question. I would
Then
hope not,
maybe-
because November is the month you want it to get out. Maybe Mike can make a
Yeah.
suggestion. Yeah.
Well, if you, in the motion, I believe I heard remanding it to having me consult with one of the tribal members, as long as it's couched that way, where you're okay with the language from that juncture, then I believe it could still be posted upon that consultation.
Then I would second that. That's fine.
Okay.
Is there a specific, Caitlin, is there a specific piece that stands out, or you're just wanting to do due diligence?
It's more about due diligence. If we're speaking on behalf of
course.
honoring people, we need to talk to these people.
Yep.
Okay, so we have a first and a second. All those in favor of the motion, say aye.
Aye.
Anyone opposed, say nay. Okay, the motion carries. Thank you. Our next piece of the agenda today is, thank you so much. So definition of diversity and inclusion. These are big topics, but as chair, I think that a shared understanding of both will help with our conversations moving forward. And I believe folks here were able to submit what diversity and inclusion means to them. I think I'm the only one, but did I send that in later? I know I sent it later, I believe. Or did you not get that from me, Lisa? I don't see my name in here.
I'm sorry, I did not get it.
Okay.
If you could send it again, sorry.
Yeah,
It
no
may have
problem.
gotten lost in my email.
That's not a problem. Yeah. And on my end, I might have not pressed send. And I telepathically think you can read my mind. So I'll double check on that. But I think the exercise was more about getting yourself to think about those two words and for us to have that conversation. And I don't want to have an extensive conversation, but at the same time, I want it to be something that is utilized on behalf of the city, that we can advise, city council. I don't know if I'm saying that correctly, but it's just helpful to have a similar definition. And if there are any members here who would like to speak up and kind of give their take, or maybe it's changed since this was written by you, I would be happy to hear from the board members. And so, because this is on our action item, we're going to need a motion. And so what I'm looking for today is defining diversity and inclusion. Just kind of surrounding our thoughts about that.
Do you have yours that you could read, Nadine?
Thought I had it here.
I mean, I could start off by just saying, I guess one of the themes I see, or one of the common goals, would be for people to feel welcome, for people to feel at home. And I think as a city, what better, statement than to say we want you here. We care about you. We're all different, regardless of where we come from and ethnics, all the different things. We're all different. That's just how it is. But we want. We're stronger because we're different, and we welcome you here. So I guess that's a watered down version, but that was a theme I saw come across.
Well,
I would agree. I think, yeah. Yes.
Sorry, go
Kayla?
ahead, Nadine.
No, I just agreed with that. So you can go ahead.
One of the things that I really appreciated about this is looking at everyone's definition of inclusion. They were all actionable. They were doing statements instead of just like these philosophy statements. We see involvement, empowerment, providing, encouraging, combination of a group of people. And I think that it's really cool to see that we're all on the same page of there being like action behind it. And so if we are to create a statement as a collective, I really think that action piece, along with what David is saying about this everyone is welcome piece, I think those are going to be, well, at least what I see from what we've written, the two main headers, if you will.
Yes. Those are important elements. Yeah, the welcoming environment, I've seen that too.
So I think I would like to make a motion that we, I don't know, I can do it, I guess, or if somebody wants to volunteer to do it, using the definitions we have here, along with the one that Nadine will submit, make one cohesive statement to be approved at the next meeting.
Okay, make one cohesive statement. Yeah, and then I can send mine over to Lisa. So the motion has been made. Would that technically be an action, Lisa? Okay, perfect. Just double checking on that. Is there a second for us, for Kaylin's volunteering to go ahead and take a look at all of them and bring something for us to vote on next time? Is there a second?
This is Ruben. I second the motion.
Okay, Ruben seconds. All in favor, say aye.
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 Okay, opposed, say nay. All right, motion carries. Thank you so much, Kaylin, for doing that for us.
Can I ask that you send me an email reminding me that I said I would do that?
And sending my definition along too, Lisa, that would be great.
Will do.
Thank you.
You are. Okay, we're moving on to reports. So we have a couple of reports today, and today we'll start off with Chief Tamaris presenting on police legislative changes.
Actually, we bumped City Attorney Colwell in there
Oh,
first. Sorry.
okay, no problem. So that's gonna be, which one is that?
Oh, I didn't submit any
Oh.
documentation to Lisa. Oh, sorry
Gotcha.
about that,
No problem.
everyone. But
You can
hopefully
set it
I
up.
can have a little bit of your time to talk about qualified immunity for law enforcement officers. I know I was slated to get that to this group. And in doing so, it's a pretty complex issue. And so rather than inundate you guys with a full legal analysis, which doing that, I just kind of want to put it in a nutshell what it is and kind of layman's terms. So for those of you that are really familiar with it, I apologize, it's going to be just basic stuff. But my goal today is just to kind of get the concept out in front of you, perhaps answer some questions. I'll just dive right into it. So basically qualified immunity is now in the public, and we're talking about this because of, kind of goes in hand with Chief Tamaris and what he's going to talk about with the legislative changes, and trying to combat some of basically police brutality, for lack of a better word. What qualified immunity is, the basic concept is if a law enforcement officer is following the law when they perform their duties and they injure another person, they are granted by the court immunity from any monetary damage. If an officer is fulfilling his duties, and I use he because most officers are he, and they make a reasonable mistake in doing that and they injure somebody, a court is going to grant that officer immunity from any liability damages. And so qualified immunity is a concept or a doctrine that was created by our courts, by our Supreme Court. And it really came into play in the late 60s, and that's right when our civil rights, our national civil rights movement was happening. And basically, it first came out in a case, and it's called Pearson versus Ray, and this is in 1967. Well, I'll take one step back and go to 1871, when our Congress passed a law that's found in 42 U.S. Code 1983. So you'll hear these 1983 actions. And this law that was passed in 1871 basically said if any governmental actor, law enforcement, violates your rights, you have a claim, you can sue that person in court, in federal court, for that violation. So we have that on the books since 1871, but it never really got much ground until the civil rights movement and the case of Pearson versus Ray. And what happened in that case is law enforcement officers in Mississippi arrested a group of 15 priests who were there to engage in anti-racial discrimination activities in Mississippi. 15 of them, 3 of the priests were Black, and they were at a cafe. And 2 law enforcement officers went into the cafe and saw this group and said, you guys you're a group, groups are scary, you need to leave, you need to not be a part of a group anymore. They And so they were arrested. And the law on the books at the time said it is a crime to congregate together in a public place that might lead to some sort of bad behavior. That was the law on the books. So the officers were enforcing the law on the books. Priests were actually convicted. They appealed their conviction up to an appellate court, which overturned it and said they did nothing wrong. This law is unconstitutional. This should never have happened. And so they turned around and sued the two officers who arrested them because the court said that they violated their constitutional right by arresting them. And the Supreme Court recognized, okay, these officers are just doing their job as they've been trained to, as has been on the books. And so they're entitled to immunity, and it's qualified by the fact that they were doing their job. So that kind of where we began. And what it has eventually turned into is a process by which if an individual believes that they have had their civil rights violated by, we'll just use a police officer, they file a lawsuit. Prior to the case going to jury, a judge makes a decision as to whether that law enforcement officer is entitled to immunity or not. And they do it based on the particular facts of the case. What it has developed into with all of the subsequent decisions is basically for a law enforcement officer to not be granted immunity. There has to be a Supreme Court decision that says particular circumstances with these particular facts, we have already told law enforcement officers they can't do that, and they did it anyway, then they're not immune. And this is my editorial. So this is me as a lawyer, me as a citizen, not necessarily as the prosecutor or attorney for College Place. It's gotten to some kind of twisted decisions, and I'll give you some of those as an example. So any questions so far? Feel free to pipe in. Good, I must be doing a good job. So the reasons why we have it and want it is we want our law enforcement officers to be able to make decisions quickly to the best of their ability without having to stop and second guess. It could be a life and death situation. So that's one reason why we want to give law enforcement officers qualified immunity. Another thing is we want to encourage good cops to come work for the city of College Place. And if our society is saying, look, if you make a mistake, even if it's reasonable, we're going to throw the book at you, it would be discouraging. And then the other is basically purely monetary. If we allow these types of cases to go to a jury and they make a decision based on facts, emotion, whatever, it's a huge amount of money. That does take away from what a government agency can provide, can spend on providing services to the public. So what are the cons of qualified immunity? Well, it's fun. Someone who's harmed, the priests in this case who were harmed and went to jail actually for this crime, they got no compensation. So as a society, we might say that's not a good thing. The other argument is having this immunity tend to make law enforcement officers less thoughtful when they are going to act, when they're going to use force. Do they know they have immunity? So I'm going to err on the side of more force than less. Another con is it may encourage thoughtless action. It may be an attitude of a law enforcement officer. I can do anything because I'm doing my job and I'm not going to be liable. So those are kind of the pros and cons of qualified immunity. When I think about it, I think, okay, has a law enforcement officer violated someone's constitutional rights? Yes, held accountable. That's really kind of the most simplest explanation. I think if you ask 100 people on the road, 100 probably would say, yeah, they should be held accountable. So I'm going to give you a really quick example of a case as to why that isn't always a good thing. So this is a case called Arizona versus Gantt. And up until Arizona versus Gantt, which is relatively recently, I can't quite remember, but it was 2004 or 5. Troy, you might remember. Prior to the US Supreme Court case of Arizona versus Gantt, if you were pulled over while you were driving your car and you were drunk or whatever, you're getting arrested for a crime that you committed, could search your car incident to that arrest. And Mr. Gantt was arrested in Arizona. And when they searched his car, cops searched his car incident to arrest, they found cocaine. And the case went all the way up to the Supreme Court. And the Supreme Court said, officers, it is a violation of Mr. Gantt's constitutional right to be free from unreasonable search and seizure for you to search his car incident to arrest. Well, the officers at the time were doing what everyone had done forever and searching vehicles like everyone across the United States. So if you had an officer search your car the day before the Gantt decision was made, that officer did violate your rights, but that officer had no idea they did. So that would be a case where if someone sued Troy because he searched their vehicle the day before the Gantt decision was made, violated my rights, we wouldn't, as a city, want to have to pay that person. Everyone up until that point said it's okay. That's an example of a case where, you know, the officers need to have some notice, you know, that what they're doing is wrong. Now it gets icky in my mind are the cases where we have qualified immunity is granted and it doesn't really sit well on just a lay person. And I'll just give you one example of that relatively recent case. I'll give you 2 examples. So a prison guard who pepper sprayed an inmate for no reason was granted qualified immunity because even though there were court decisions that said hitting or tasing a prisoner for no reason violated a prisoner's rights, there was not a case out there that said pepper spraying an inmate for no reason violates their constitutional right. To me, but it doesn't seem like using any force on an inmate for no reason, and everyone admits no reason, that prison guard should have been granted qualified immunity. Second one is officers who stole $275,000 during a legally executed search warrant were granted qualified immunity because at the time that it happened, the court ruled there was not any clearly established law saying that officers shouldn't steal that money. So the concept of qualified immunity stems from a balancing of our public needs and costs, but I will agree with you, it's gotten perverted into a lot of other situations that you kind of give your, scratch your head. So the question is, what do we do now? What do we do? Colorado and I think Vermont, but I know Colorado has passed a state law that limits qualified immunity for law enforcement officers. And it requires the employer of the law enforcement officer that is held liable to be responsible for paying any damages and attorney's fees, unless that officer was violating a law, was acting against. In that case, that officer is required to pay $25,000 or 5% of the judgment, whichever is less. So there's not as much exposure on the law enforcement side. And how this US Supreme Court works is what they say is the law. And so the lower courts are hesitant to make a decision that's different than what the Supreme Court has said. I do think that there are going to be some cases coming before the Supreme Court in the next decade or so that's going to talk about qualified immunity. And there is one exception to the qualified immunity, and it basically is, let me find it, where are my notes? Basically, when something is so egregious that government actor should have known that they couldn't do that. And there was one case where an inmate, seems to be prison guards, an inmate was shackled to a hitching post in the sun without a shirt for 7 hours, given 2 glasses of water and no bathroom break. And the court recognized there's no other case out there that says you can't do this. This is illegal. But they said it was so obvious that those officers did not get qualified immunity. So that's kind of it in a nutshell. Does anyone have any questions? I know it's a very complicated topic, and I'm more than happy to discuss it at future meetings if need be. One of the questions I will say, just summing up, that was posed to me was, well, why don't we let the jury decide, right? We go to court, we have this set of facts, a judge decides you have qualified immunity. The case doesn't go forward, doesn't go to the jury. Why don't we let a jury decide whether law enforcement officers knew or should have known what they were doing was not right? And basically what the courts have said is our time is valuable. We can't litigate all these cases. And why should we go to a full jury trial when the circumstances most likely are going to be that law enforcement gets immunity? I don't know. I think that's kind of a cop out, but that's my opinion. So any questions, concerns?
I have a question. This is Kaylin. When has qualified immunity been invoked, if you will, in our city?
I don't think that we have any law enforcement officer from College Place that I'm aware of that's ever been sued. And I will tell you, one of the things that is, as a lawyer, I have an ethical duty to defend my client. So if I have a case with a law enforcement officer and everyone's looking at this case and saying that law enforcement officer toast, they just did something horrible and we should just step up and do whatever. If I were that law enforcement officer's attorney, I have to fight tooth and nail to defend that law enforcement officer. So I think there is a bit of perception that, okay, we're defending these law enforcement officers, we're not accepting responsibility, they've done this horrible thing and we're still backing them. I think you have to kind of divorce that from the employing agency, the city, and then the officer's attorney. You know, if I were the officer's attorney, I have to put it forth in defense, and in some cases, qualified immunity is. And I'll just add one other thing. I think we don't see cases where qualified immunity isn't granted, because those are the cases where I think the decision makers look at a case and say, yeah, our guy was wrong. We're going to pay to make this right, or at least try to make it right. So those cases don't get litigated. And thankfully, they're not here, not in our neck of the woods. So.
Can I make a couple quick comments?
Yeah.
So just, just so everybody understands what qualified immunity is, it's for all government agencies and employees. So it's not just law enforcement. Right now, we're getting the bulk of that attention for obvious reasons, but it's important to remember that it's not a law enforcement protection. Secondly, according to WCIA, Sean pulled some data for me here literally about a year ago. There hasn't been a qualified immunity case in the state of Washington in almost 10 years. So it's just not as prevalent as everybody thinks it is. And, I've been doing this job for 31 years. I know lots of officers, troopers, and deputies have been sued. And cities, counties, and states have paid out millions and millions of dollars when officers make mistakes. So it doesn't keep people from getting a settlement when there's negligence involved. And furthermore, it doesn't keep an officer, deputy, or trooper from being prosecuted when they commit a crime. So I think that's a misconception of what qualified immunity is. I think we're making a bigger deal out of this than we should, frankly.
And Chief, I think those that beat the drum, as they should beat the drum, it's easy to find these cases that just shock you and realize that the law enforcement officer, there's no responsibility, at least on a money level. Of course, they probably aren't employed anymore. But yes, there's all sorts of causes of action. For instance, the city could be liable for negligent hiring if we hired someone who is a sex offender, child sex offender, and we didn't do the background check and we let them work with kids. The city would be liable for that. It's not just law enforcement. Thank you.
So my question was around just timing wise. Is there anything in the near future that is coming up besides Supreme Court and it being in the news? Is there anything specific to the state of Washington where qualified immunity is, I mean, it's a hot topic everywhere, but specifically?
Yeah, I think that there isn't any that I know of in the court system, but I anticipate that we'll get some legislation out of Olympia that will address this. And it may be something that's similar to what they did in Colorado. And I can get that information to you guys. But basically, the problem that Colorado is solving is having a venue, having a place where individuals who feel they are harmed by law enforcement have redress. And it's just extremely, extremely difficult to, I shouldn't say that. It's not an easy road through federal court under a 1983 action. And a lot of times, might get arrested and you're out of jail the next day and they shouldn't have arrested you. How much damage is 1 day in jail? What does that mean? As is a private attorney going to sue a law enforcement officer or whomever for 1 day in jail? So there's a lot of issues with trying to hold law enforcement accountable through the court system. And I think what Colorado has done is said, okay, here's an avenue where we're going to let a jury decide. And the employing agency is responsible unless the law enforcement officer basically committed a crime. I anticipate that will happen in Washington, absolutely. Honestly, I think our cops are amazing, so it's not going to be any skin off their nose if it happens. So they'll just keep doing the job that they've been doing.
I appreciate the update and just understanding. I think it's very useful for us to be educated in that, because you're right. We hear the one-sided, the really far off voice over there. So thank you for that recap. I learned a lot.
And what I can do too is I have my pulse on this. So as things come down, I can bring it to your guys' attention. It's something that I think would be interesting to you, or a big change.
Sounds good.
That's all I have for you guys. And if anyone wants to discuss in detail more, come visit me. Thank you.
Perfect. Thank you so much. Next we have Mr. Rizzatello. Oh no, now is it Chief Tamaris? Yeah, okay. He's gonna give us a presentation on police legislative changes.
Okay, it looks like Lisa's giving me the screen, so let me get this set up. Okay. All right. So I think the majority of you, since this has come out in July, this is a lot of information that's come out. I'm sure the majority of you have heard or learned a little bit about this. In fact, I've had conversations with everybody on this panel except Kaylin, I think, as far as the law enforcement reform bills. But let's go through them. I'm glad Ree's here. Ree, give me your feedback on all of these things too. And then stop me at any time if you have questions as we're going through this. So, All right. So these are the different bills that we're going to go through. We're going to go through each one of these individually here, and let's get started. So the first one is House Bill 1223, which is the Uniform Electronic Recording Custodial Interrogations. This requires that any custodial interrogation that has any express questioning or other actions by words of law enforcement officer likely to elicit any incriminating information must be recorded. Now, this was intended to really push departments to get body cameras, which we have. So this is really easy for the College Place Police Department to comply with. So it specifically is anything felony or greater for adults or any juveniles. So it's pretty simple and straightforward. This one here is House Bill 1140, which is the juvenile access to attorneys. Basically, it prevents a law enforcement officer from talking to a juvenile without having them notify or reach out and make contact with an attorney. In fact, they cannot waive their right to an attorney under this new law. There are some challenges with this. I'll go over them with you. But so basically, anytime you have a juvenile that you are going to turn from investigatory to accusatory, there's a fine line there where you start thinking, okay, this individual may be involved in a crime. At that point, you have to notify them that they need to reach out to an attorney. And this has been a really frustrating thing for me and my officers. We've had several of these cases. It's almost impossible to talk to a juvenile now, but we've had several cases right now where we've reached out to the on-call attorneys that have been assigned to take these juvenile calls, and they just refuse to talk to the juveniles. So it's so at that point, just everything's done. So it's been a frustration. So at this point right now, I mean, what we typically do is if we have a crime where we believe a juvenile needs to go to the Juvenile Justice Center, JJC, we just take them down there and we do our investigation without talking to the juvenile. We try to collect our information from other juveniles or other witnesses, and we go with that. Any questions on that?
I don't fully understand. You say you talk to other juveniles. How do you talk to them if it's?
They're witnesses. They're not.
Oh,
they're
okay.
not. Yeah, I'm sorry.
Because you're not accused. Thank you.
Yeah.
Troy, I have a question. Sorry, I know I'm not part of this.
Oh, you are, of course, Mary.
Are those local attorneys that are declining to assist?
They are. Yeah, we're working with the prosecutor's office. They're aware of it. Reed's aware of it. It's frustrating.
Yeah,
So
for the least.
we're working with them. They're getting paid to as public defenders to take these calls, and they're not cooperating. So it's been a really frustrating thing for us and our officers.
Do you have it?
We're hoping that the prosecutor's office will solve it because juvenile prosecution is handled by the county prosecutor's office. So these are their cases that they're prosecuting.
How many lawyers do we have on? Two. Okay. All right. Thank you.
Yes. And, the juvenile laws have changed so much, and Reed's right. All the juvenile prosecution is done through the county prosecutor's office, and they can get unlimited deferrals. So you can, I'll give you a quick story. We had an incident where a young man had shot his sister with a BB gun twice in the back. The BBs had to be surgically removed. We took the individual and booked him to the JJC for assault, and he was out within an hour of the JJC and back home, back into that same environment where the sister was living. So they can be deferred as many times. In fact, they're automatic diversions. Now we're learning now as a result of that case specifically that we can make appeals, that if we feel there's a threat to the home or a threat to society or the community, we can appeal, and the JJC can make an appeal. They'll retain that juvenile longer than the release. So we're working through this. That's the big thing with all these changes in the laws. We're all working through it together, not just me, and my officers, but also the prosecutors and the defense attorneys and the judges. Everybody's trying to figure some of this out. So it's been a long process since July, but we're getting there. Okay, this is the State versus Blake decision. Basically, this amends the Uniform Controlled Substance Act that specifies that knowingly possession, you have to prove knowingly that the person was in possession of a controlled substance. And it's taken all felony personal drug possessions and turned them into simple misdemeanors. Furthermore, that an officer comes in contact with someone, say they have a gram of methamphetamine, we can also not arrest that person until they've been arrested 2 or more times previously. And I shouldn't say arrest, physical arrest. It would be a deferral or a referral. So what this looks like is we come into contact with an individual, say they have possession of methamphetamine or fentanyl or Mexi, and we give them a referral to get some drug treatment, get some help, some counseling, some substance abuse disorder assistance. And then we document that referral. We now have a system through our statewide sector system. We document that referral. And then if they've had 2 or more previous referrals, you can then physically arrest that individual and charge them with a misdemeanor. And now we're not talking about the sales of drugs or large quantities of drugs. We're talking about personal use at this level for the state versus Blake. Ree, what else am I missing on this?
You're good. You're good.
I do have a question on this one, Chief.
Yeah.
The referral process, where locally do we refer them?
We're using so we have a couple different referrals here through comprehensive health that we have the ability to refer to. We have our local CIT that we can do referrals to, but right now we're providing to comply with the mandate. We're providing the statewide referral hotline and email system so that they can make a phone call and get immediate help if they choose to do that. But it's really up to them. It's really up to the individual to make that choice. It's not, we don't force them to do it. It's really a compliance thing, an honor system. We document that they've been given the information, and we document it in the computer that this person's had a prior contact. And with the new system that's in place, if an individual has 2 referrals in Bremerton and then comes over to Walla Walla for spring release and gets arrested a 3rd time, you have that information now anywhere in the state. Doesn't work out of state, but it does in state.
Okay, and I have one more question, I'm sorry.
Sure.
And this might be more for like Rhea. A few months back, we were talking about a deferment, like a deferral process for like misdemeanors and smaller crimes. Would the program we were talking about, and David, maybe you can answer this a little bit more, also be able to help serve these people with addictions?
So that program, we have the LEADS program, which is Law Enforcement Aided Diversion, and that's a funding through Washington State Patrol. And so that, I don't think that's what we were talking about. The other one we were talking about is a separate diversion process that College Place has implemented, and those cases are going to Blue Mountain Health Cooperative. And so the ones that we believe substance abuse or mental health is the driving force, those will be referred under LEADS, all other things considered. And if substance abuse or mental health issues is just a component and that we don't necessarily want to fill a spot at LEADS with those, there might be other socioeconomic conditions. Those, if they qualify based on about all the stuff that we consider, we've been referring those to Blue Mountain Health Cooperative, and they do an assessment that includes substance abuse and mental health.
Awesome, thank you. Chief, is there a way for the card or whatever it is that officers give out to also include that kind of information, that instead of just, obeying the mandate, but giving them local resources? I mean, who knows if it's going to help or not, but if I have help closer to home, I'm more likely to get it.
So that statewide number is 24 hours. And what they do is they connect the individual with the local resources that they need. That's the intention behind it. So it's not like you might be talking to someone on the other side of the state, but they're immediately making contact with local resources to get that individual. So if they say, hey, where are you living right now? Where are you at? Hey, I'm in College Place. Oh, that's Walla Walla County. They put you in contact with the resources you need here in our county, in our city.
Okay, and that information, that spiel of like, hey, when you call them, they're going to direct you locally. Is that something
yeah.
that officers are saying?
Absolutely. Yeah.
Awesome. Love to hear it.
We're trained to tell them that. And then, the other thing too, that, we talked about the law enforcement assisted diversion program. So those are diversion programs that come through either myself, or a private citizen. So if you have an individual that has a drug dependency or mental health component, and you believe that they are either committing a crime or potentially could be committing a crime as a result of those dependencies or mental health problem, you can make that referral. So Kaylin, if you know someone that you think that could benefit from that program, they can put them in contact with someone that can help them as well. So it doesn't necessarily have to be a crime.
To follow up with that, Chief, I think shortly the city, mayor, and Mike, we are going to put our heads together with the LEADS program and get some messaging out to the community. That is basically just what the chief said, that's available. It doesn't have to be someone who's that should be on the reader board and things like that.
What I do like about the LEAD diversion program is it does have some leverage. So, if you have someone who is struggling with chemical dependency, and we all know those people, and some of us have had them in our families, so we know exactly what I'm talking about here. But if you don't have a little bit of leverage, oftentimes they won't seek help for themselves. So what's nice is, in lieu of a charge, a crime, we try to do the diversion before it gets to the court. But they assign someone to deal with that individual, to kind of hold their hand, take them somewhere, take them to their clinic, take them to their first appointment, whatever they need to do, they will do it. If a person says, nope, I'm not going to do it, well, then Ree still has leverage that she could prosecute that individual if she deems necessary, if that would be better for the community. So I like the leverage with that because it just kind of like, hey, you know what? You need to do this. So this will keep you out of going to court, having to pay fines, spending your night in jail, that type of thing. So I really like it. I think it's a good program. I mean, we're kind of getting momentum with it still. We're getting going with it, but I think it's got a lot of potential. Any other questions on State versus Blake? All right, let's get to the next one. This is House Bill 1054. This covers the big ones of vehicle pursuits, but it also covers the tear gas, chokeholds, canine military equipment, uniforms, and so there's been some unintended consequences as a result of this bill. It says anything with 50 caliber or more. Well, the unintended consequence right away is we have less lethal weapons or tools or instruments, such as a beanbag shotgun that we all carry. And we also had 40 millimeter baton, foam batons that we were able to deploy. These were less lethal tools that we could take in a critical incident. But as a result of the law, the unintended consequence, we had to remove those from the officer's ability to use. So right now, all the officer has are lethal options, with the exception of a taser, but the taser is really limited. And from proximity under 20 feet and these types of things. So that's hopefully these are one of those bills that will get amended a little bit so we can get some of those tools that are really important. I've seen personally the foam baton used. I've seen personally the beanbag rounds used. The beanbag round was used in College Place June 8th, 2017, when Sager School was attacked. The young man had a spear and was challenging an officer, and the officer was able to deploy the beanbag round, which caused the young man to drop the steel spear. So it's an effective tool. So we'll hope to get that back. The big one for us, obviously, is pursuits. Basically, officers are no longer able to be involved in a pursuit unless there is probable cause that the individual in the vehicle has committed a violent offense, such as a sex offense or homicide or escape. But even with that, it has to be imminent. It has to be supervised by a supervisor. And So we just don't, in 31 years of my career, I've never seen a pursuit for those things. So, I mean, not to say it can't happen and it hasn't happened, it has, but it's just really rare. So the consequence of this, perhaps unintended consequence of this, is we're having many people now just not stopping because they know we're not going to pursue them. They just don't stop. You go to make a traffic stop and they just don't stop. So we've had several incidences in College Place and in the county and Walla Walla where this is occurring, and it's also occurring in many places across the state. So I could tell you other stories from across the state, but it's just hopefully some of this gets changed back a little bit as well.
So Chief, I just need some help with language. What is a pursuit defined as?
A person who is trying to recklessly evade you is basically the definition in layman's terms, but it's someone has to be driving in a willful and wrongful disregard for the safety of others. They are recklessly attempting to elude a police traffic stop. So if you have a person who's going, you hit your lights and they're still going the speed limit, but they're just not stopping, that is not a pursuit. That is a misdemeanor, and that is just failure to comply and not pull over. But a pursuit would have to be reckless evading. Does that help your question?
Oh yeah, for sure. I was like, yeah, that helps.
I wanted to ask Chief too, you mentioned that there were some unintended consequences. Have those consequences been made known to the legislature? Because I think I heard later on in August or something that there was going to be something around specifically the less lethal military grade weapons.
Yeah, so we don't have any military grade weapons in College Place. I don't know of any. I've never known anybody to have any military grade weapons that I've worked with. But there has been a request by legislators to take a look at this. Legislators have made, actually our legislators locally in Walla Walla have requested to the Attorney General's office for clarification on not just this law, but several of the other laws as well. We have not received an official response. We did get it's coming response, but the Attorney General does not plan on responding to these until February of 2022.
Chief, this is Norma. I have a question. So I'm trying to get a scenario.
Sure.
So let's just do it, make believe. Let's pretend that there was a hit and run. A vehicle hit another vehicle. Police didn't see it, but witnesses did, called it in. Police see that vehicle driving down the road. Are they allowed to pursue that vehicle?
Well, we would certainly attempt a traffic stop, but if the individual failed to stop and began to drive recklessly to evade us, we would not be able to pursue that vehicle.
Okay. Wow. Thank you.
The big case in Seattle, everybody's talking about it. I'm going to mess up some of the details, but basically it was a couple stolen vehicles. I think it was stemmed from an accident, stole the vehicle, committed an assault, stole the vehicle, and they were not able to pursue the vehicle.
They just have to let them go.
Let them go.
How incredibly frustrating for you all. For anyone who had to witness it, even a victim or witnesses who saw it and called it in, and just to hear that there's nothing that they can go after them.
Well, the hard thing is that we need to really consider is the criminals know this. They know, and they're very good at deciphering what this information is, and they share it with each other, and they know that they can just drive in a reckless manner and evade us, and we will not pursue them.
Chief, I know you mentioned you didn't get anything official response from the Attorney General, but are there other, and this might be for Rhea, are there other, the letters or opportunities where the Attorney General has made an official statement and that statement could be used to clarify anything?
No.
No.
Not on the vehicle pursuit.
Oh, yeah, no, not on the vehicle pursuit. I think The one I heard about was about, actually, it's going to be one of the ones you're talking about later, but police responding to any crime. Or sorry, well-being, caretaking calls and well-being check-ins.
So I'll just jump in here real quick for brevity, if that's okay, Chief. So the Attorney General's office came out and said, basically the new law doesn't change anything with law enforcement interacting with person who is in a mental health crisis. And it's, again, this is me as an attorney editorializing, not necessarily a position of the city. It's kind of like, yes, we know as law enforcement officers when someone is in crisis, and we have our behavioral crisis response team come under the law enforcement is required to assist in the detention of that person who is going to be committed into an involuntary treatment facility. Problem with that is we do that happens, but those are rare. In almost all cases where we have a mental health issue or behavioral health issue call out, they are not going to be taken into custody. They aren't committing a crime. They're not going to be taken into custody. So law enforcement isn't commanded to take that person in custody. And so basically they just aren't going to go unless there is a crime. So that is where the Attorney General's opinion was not very helpful. And I don't think was intended. I just don't think he works on the ground, the boots on the ground, and doesn't really know the reality of what's happening. So did that answer that, Troy? Did I answer that correctly?
Yeah, and when we get into use of force, I'll kind of touch base on that a little bit more, but yes.
So I have a clarifying question. My understanding is that this bill does allow for pursuit with approval from a sergeant or yourself. Do we have enough staff members that there's always someone that can approve a pursuit on staff? And if not, what are we doing to try to make that an option?
So you have to have a qualifier of probable cause. I kind of glanced over this, but there is also, if the person is under the influence, you believe them, suspect them to be under the influence, you can pursue those individuals as well, which is a gross misdemeanor. So that was a little surprising that's in the bill. But if you meet the qualifications of meeting the standards to pursue, you also have to have supervisor approval. So you have to first have the standard, and then you have to have supervisor approval. We only have 2 supervisors working in College Place, typically, well, including myself, that'd be 3. So no, we to make it easier, yes, you would need more people, or they can do it by phone, but they'd have to immediately get out in their car and manage the pursuit, or be on the radio and manage the pursuit.
That sounds pretty unrealistic to happen. Am I hearing that, assessing that correctly?
It's extremely challenging. Yes, Mayor.
Okay.
Pretty hard environment.
And I'm sorry, what makes that challenging if they can make a phone call? I mean, you are the expert here, not myself. I'm just trying to wrap my head around it. If something happens with one of the officers, they say, hey, chief, pretty sure this person's intoxicated. Can I pursue? You say yes. What am I missing?
Well, how long are you going to pursue that vehicle before you get a hold of your supervisor? You're pursuing someone at 100 miles per hour, and at the same time, you're trying to call them on a cell phone or having dispatch call them. And how long is it going to take to get a hold of that individual? It's just not realistic.
Okay, I'm going to follow up one more time. Okay, let's say that they get a hold of the supervisor. What liability is there on the supervisor should you say, yes, go ahead and pursue, and then it turns out, I don't know, bad, or, for lack of better words, because I'm trying to think of why if at some point would a supervisor say, I don't want to take this responsibility of approving this.
And that's their choice. And the officer can also make that choice. You know what? I meet the qualification. This particular incident meets the qualifications, but does that outweigh the safety of the community? And those are conversations that we have as officers, because you know what, my family drives on these roads, your family drives on these roads. So that is something we have to. I've been involved in many pursuits over my career, and many of them do not turn out well. So it's something that you have to really consider, which is what prompted this law. But the problem with having a law like this is it really benefits. You still need to have the ability to use discretion, and you no longer have that ability to use discretion. And you get discretion through training experience, and that's been removed from the officers. So it's unlikely we'll be involved in any pursuits in the near future.
And I'll just add, I think a lot of this legislation comes from other states, and Washington is relatively good. And if you put down 100 fact scenarios of what you would and wouldn't do prior to this law, 99% are going to be the same thing as you get under this law. And what I think they're really trying to combat is that a vehicle is not a deadly weapon. So law enforcement officers should not shoot at a deadly weapon. And that's something that happened extremely rarely in Washington State, but has happened in other places where hindsight's 2020, you look back on it and say, man, it'd be just better if they crashed their car and no one would be dead, kind of thing. So it's a rule that's trying to fit. It's a rule that's trying to reach an outcome that I think our law enforcement officers have strived for. When something gets dangerous, they stop pursuing. That was in place before this law even came down. So.
Okay, so let's move on to the next one. Thank you, Ree. This is 1088, the potential impeachment disclosure. This has already been on the books. The prosecutor's office already has written protocol for this. This is a pretty standard thing. They're just updating this and requiring the protocol be done yearly instead of just having a protocol. There is something called the Brady disclosure list, which is when an officer gets put on that list when, say, they were involved in a truthfulness situation or a crime. There are no officers in Walla Walla County that are on this list, so we're very proud about that. But anyways, that is this really affects the prosecutor's office more than anything. Anything to add to that, Ree? Okay.
Other than if you are found to be dishonest, don't ever testify again. So basically you can't be a cop anymore. And that's ridiculous.
No, my officers know if you lie, you die. I will not tolerate truthfulness issues, and you will not have a job here at College Place Police Department.
And just so you guys know, if say, for instance, law enforcement officer fudges on his timesheet and it turns out that he's been saying he's worked more hours than he has, that person would go on a Brady list and they're not going to testify ever again.
Okay, let's go to any other questions? For the next one. This House Bill 1267 creates the Office of Independent Investigations. This will be a law enforcement agency that falls within the governor's office, and essentially this will require by 2022, July of 2022, they will oversee officer involved shootings. Now there's already each region we have what's called the Special Investigative Unit. We call it SIU. We already have the very best detectives who have been vetted under the previous laws and trained to conduct officer-involved shooting investigations. The Office of Independent Investigations will oversee those investigations. They will audit those investigations, and they also have the ability to show up on scene and take over an investigation if they deem necessary. Now, they're a long ways from being able to do that, because they're just getting up and running. So, and they have to hire people who have training and experience, probably retired law enforcement is my guess, and people who have done this in the past as detectives. But we do have an independent investigation team that investigates officer-involved shootings. So if a college one of my detective, Brian Fortin, is one of those members of the SIU. He was recently involved in an investigation in the Walla Walla shooting. If a college police officer was involved in an officer-involved shooting, we would not be able to participate. It would have to be outside independent investigators that would come in and do that. So, but the bottom line is the Office of Independent Investigations was created to fall under the governor's office, and they will be responsible for the oversight of these investigations. Any questions? Okay. This one here, I'm still a little bit confused on. I think we're still waiting for some clarification on. It doesn't really affect the officers and how we go about doing our business or protection orders, but this does consolidate and amend some of the laws governing protection orders. And Rhea, have you gotten any updates or anything to offer on this?
I don't, and it's just, the law is like 3 inches thick when printed out, so I haven't tackled that yet.
Yeah, this has to do more with the county prosecutor's office who and the judges who petition these orders. Okay, so this is the final one. This is the use of force. This is the big one. So basically, the hard part here, and Nadine, this kind of gets into your question earlier. It changes reasonable suspicion to probable cause to be able to make an arrest, effect an arrest, or prevent an escape and use, or there may be force used. So I think what people don't understand is force, it could be, the majority of our use of force cases in College Place and really throughout my career have been, hey, you're under arrest. No, I'm not. And they take off running and you grab them and you fall to the ground, put handcuffs on them. That's a use of force because you go to the ground. That's what the majority of use of forces are. I think we all have worst case scenario use of forces in our minds, whatever that might be. But the bottom line is that you cannot, you have to have a crime now, probable cause, before you can respond and then potentially be put in a situation where force could be used. And that's what kind of gets back to your question, Nadine. The I-940 de-escalation training that we all went through here this last year, which was 16 hours. We have, 32 hours. We'll have another 16 hours here the next year or two. But that falls under the new duty, creates a duty of care, reasonable care for Washington law enforcement that requires, when possible, that an officer exhaust all available and appropriate de-escalation tactics prior to using force, which we've always trained to do. But it requires you to think about your time, distance, and cover, which is what we're trained to do, which is great. Making sure that we're calling for additional resources, including backup, which can be very challenging when you're working as an officer in the city of College Place, because it's quite often that you're by yourself. We do rely on our mutual aid partners with the city of Walla Walla, the State Patrol, and the County Sheriff's Office, of course. Designate a officer to be the communicator. So basically a cover officer is the communicator and the other officer is a secondary officer observing what's happening. Obviously taking time with the individual, not rushing through the call. And then of course, leaving the area if there's no imminent harm or if there's no crime that's been committed, which leads to, we get calls oftentimes that are civil, and we just can't go to those calls anymore. There has to be a crime. Rhea, anything to follow up on? Any questions on that?
My question would be, what is considered, because you said, if it's a civil call, we can't go. What is the escalation to the point where you can go?
Sure. So let me give you a real common one where we end up going. This is kind of what we've learned to do. So you get a call from a business owner that says, hey, there's someone in my store, I want them to leave. Well, at that point, there's not a crime there. So we have to communicate with the person that's on the 911 call, maybe through dispatch, to say, has the business owner requested the person to leave? Yes, no. Well, if they haven't, tell them to, and then tell them that they're trespassing. So if the business owner says, you are now trespassing, get off my premises, now the officer can respond because now it's a crime. So that's kind of the balancing act on some of these calls. Another call that we get pretty regularly is, hey, my son, he's depressed and I'm afraid he's going to commit suicide. Well, in the past, we would go to those calls. We'd try to talk, we'd engage with the individual. Hey, can we get you some help? We'd partner with CIT, we'd partner with the fire department. Let's all go in together and see what we can do to help this young man. Now we cannot go to those calls because it's not a crime to kill yourself. That is a civil call. So what we do is we request through dispatch to have CIT respond. So that's a hard one for us. Does that answer your question?
Yeah, can you tell me what is CIT?
Oh, yeah, that's my mind's going blank here. It's Bree, help me.
Crisis
Crisis intervention team.
Yep, that's it.
Crisis intervention team. Sorry, it's been a long day. I'm at a conference, by the way, here in Skamania.
Ooh,
Yeah.
I'm jealous. Love that place. I did have one question. So these laws were being worked on, and I've done some research, and it said that law enforcement was involved. And I know when they say law enforcement was involved, it doesn't necessarily mean that law enforcement was at the table at all times. But do either of you know if anybody in our Eastern area was involved in the legislation talks? Because I have a feeling that was not the case, but I don't know if you know that.
So yeah, absolutely. So I'm at the WASPIC conference right now, the fall conference. That's the Washington Association of Sheriffs and Police Chiefs conference. And WASPIC has professional lobbyists and subject matter experts that did testify. They go to the committees and they testify on these House bills and talk about, hey, if this passes, this is what's going to happen, or hey, this will be an unintended consequence if this passes. So there was a lot of testimony on behalf of WASPIC, which we are members of, on behalf of many of these laws, but it was just, it was passed anyways.
And was it a year or a year and a half, where that kind of, I mean, you don't have to know that, but it wasn't like a few months, was it? That all of this conversation was taking place? Because my understanding it was over a year.
It started, well, now there's been several of these bills they've made attempts on passing in the past and didn't have enough votes to do that. So
Gotcha.
with all of the social and justice reforms that were occurring over the last year, as a result of several of the things that we saw on TV that we've all witnessed, unfortunately, it did create some momentum to get these things pushed forward.
Okay.
It was between January and, this last session. It started in January of 2021 and it was passed July 25th of 2021. So I say short time, but yes, you are also right, Nadine. I think a lot of these have been kind of pushed over the last year or two, and it just got the momentum to get them pushed through.
And, I think it's important to acknowledge both of those things, and also acknowledge, I know you said, things that we see on TV, but some of us have personally experienced those things, family members. I've had family members who've been, experienced things. And so those are realities. They're the real people that it happens to. And I know, I've done my research, and the intent isn't always what the outcome is. Intended consequences come of it. And I appreciate you being very transparent and keeping us updated. I think it's amazing to have you keep a chief that keeps us updated. But at the end of the day, I do, see my role as a community member at making sure that our community has expectations for our police, and we're making sure that those are being met within the law.
Absolutely. And Nadine, you shared your story with me. I appreciate that. And I absolutely understand that we all, and every time I hear a story like that, I just cringe because,
Mhm.
I've lived my 31 years of law enforcement. I've been very proud of my profession and the individuals I've worked with. And I've asked a couple of you, would it surprise you, my 31 years, I've never seen an officer use excessive force. I've never seen an officer do something criminal. I've seen officers make mistakes because we're human. I've seen officers have bad days, but I've never seen anybody do anything criminal or negligent intentionally. So not to say that those things don't happen, because I know that they do. And I think at the end of the day, you need to have an organization that has strong accountability. They have leaders that are trained well and that are engaged with their employees, who are engaged with the community, which we're trying to do through the Diversion and Inclusion Board. This is really what's important. You are a sounding board for me, for the community. And I need that feedback, and I really appreciate it as well. So it goes both ways, Nadine. Thank you.
Thank you.
I just want to go back to the civil call, the suicide comment. So I just, again, clarity. So if there is a call of a suicide attempt, self-harm, suicide warning, anything like that, a trained counselor is showing up to those scenes.
Maybe. Not 100%, honestly.
And why is it not at 100%? Is it because we don't have like the people? Like what is preventing that number from being 100%?
Well, there's limited resources for sure, but I also think that their training and comfort level might not be in a position to go into an environment like that, because they have to take care of themselves as well.
Okay, and then I guess this next question is for someone at the city. What are we doing to make sure that those people are trained? If those are our first responders in regards to protecting a life and suicide prevention, which is something that our city has said that we are working towards doing, what is it that the city is going to be doing to offer trainings to counselors and to the people who might be called out?
Well,
This is Ree. Yeah, go ahead, Mike.
Yeah, well, I would say what we serve on board with Walla County. They do levy that behavioral health mental tax. And then as such, with ARPA funds from all the respective agencies, we've helped in that regards, also writing grants to provide more trainings. I mean, there is a very large grant that the College Place Behavioral Health Coalition landed that did just that. So it's a work in progress, but we are definitely trying to obtain and leverage the funds to holistically give training to everyone, and also increase the depth and breadth of services of comprehensive mental health. Because I will say, for the service call volume that they get, as well as this lack of staffing, it is an ever evolving thing, and they do need additional staffing because, much like everyone else, they're struggling to hire folks. So we're stepping in where we can, provide the grants, among everything else, provide the training, and then they're also looking to get people hired. And then again, just learning all of the newer regulations, because I mean, over time at the state, I would say the whole paradigm has shifted, where it went from more of a state behavioral response and mental health hospitals to where now it's more of like a privatized thing. So that's what we're doing in that regard. And then Reed, do you have something that you had to add?
I was just going to say that part of the struggle I think that our crisis response team has is we just don't have the resources to back them up. So a lot of times they will go into a situation where we believe that someone may commit suicide. And I mean, it's as simple as, are you going to kill yourself today? No. For an appointment tomorrow? Yes. They don't meet the requirement for being committed involuntarily. And so they're just, I mean, their hands are tied just as much as really a family member who's trying to get help for someone, or a law enforcement officer who's trying to get help for someone. And it's discouraging for them as well. They're just, we're, I think I said this before, I think we're 48th out of 50 states in what we spend per capita on mental health services. I mean, we are just horrendous. And so there's just a complete, the city, this is the organization I've worked in, is singularly more proactive than any other place that I've worked at or seen. It's expensive, and they're just don't get that support from the state.
And I'm going to throw in there too, if a dedicated crisis responder from CIT responds and conducts an evaluation, and they can still, under the Involuntary Treatment Act, an officer can show up and assist them and take that individual into custody and use force if necessary. But they have to have the Involuntary Treatment Act has to be gravely endangered, threats to others or threats to themselves, evaluated by a dedicated crisis responder. And once they sign that form, it's basically like an arrest warrant. And then we can take that individual into protective custody and get them to a clinic for help. So we have several of those we've partnered on, and we continue to partner on those. And there's been times that we've gone, we know that a crisis responder is going to knock on a door. Even though we can't be involved in the call, we may be parked across the street. So we're doing everything we can to be in close proximity and assist them whenever possible. So we're doing everything we can to comply with the law and still provide a service to our community.
Awesome. Well, and I think that what you guys are doing is great. I mean, I think we speak so highly, and I think that most of us on the board also think very highly of our officers, specifically in College Place. But I guess right now I'm asking the city, whether that be Norma or whether that be Mike, what is it that we are actively doing so that we are not exhausting this resource? And what are the steps that we are taking? And maybe you guys need some time to think about it, come back to us, what have you. Because as a high school teacher, I deal with suicide things on the daily. And so I want to know what kind of supports there are out there and how we as a city are protecting our youth and all of our people with mental health illnesses.
So this is Norma. Mike or Ree or Troy, perhaps you can answer this question, because I can't remember the organization, because I just had a meeting last week with Commissioner Tompkins. And I learned something which I hadn't realized. The crisis response teams, who are they supervised or managed by? Because it's not the county, it's not the state, it's another organization, and I can't remember the name of it. Do you remember?
Well, I know there's grants out there. WASPIC has one of the grants that's provided to them.
Right.
But there is state funding, there's local funding.
Yeah, I haven't been doing this. I've been out of the county system, but we have a region, don't we, Mike, for behavioral health?
Yeah.
That's like Benton County, Garfield County, Walla County.
It is. It's Columbia County, Walla Walla County, and Garfield. And then basically, we've been able to leverage grants to essentially grow the breadth of comprehensive mental health. Because again, in this state, it isn't really done by the state. It's done by more of like a network of nonprofits. But the issue is you also need people to fill those positions. Right. And that's also been the issue, much like everyone else, that they do struggle to get folks. So one half of the equation is getting the money and getting the sustainable funding source, which we have with the behavioral grants, and then also the sales tax that's levied across the state. But then it's also continuing to get the word out about the vacancies they have at that agency, because that is an issue, and it's a reoccurring one. I mean, that isn't the only sector facing it either, but it's an important thing to know.
So I know, so for example, the crisis response team that are working with comprehensive healthcare, so they are managed and funded through, I can't remember the acronyms, because the county was saying how they're frustrated as well, because that's been taken out of their hands as well. So we are not allowed to interfere with those people in the sense of how they're training, what they're supposed to do. They don't belong to us. They belong to a whole other
Yeah.
entity that was done by the state, and which leading to the state is very dismaying to know that this state, as much as we talk about caring for people, they are not funding to care for people and putting that heavy burden on local agencies without our ability to be able to do it. And then lastly, as the executive director of the health center, which provides mental health care to high school and middle school students directly, I know the frustration of, I have 3 openings right now, and I have had all year 3 openings for mental health counselors that I cannot fill because there is no one wanting the job. So it's very difficult, Kaylin. It's, you know, as much as we want to do something, we're not allowed to interfere with another agency's people. We can only work with the side with them, but we can't tell them or train them, or because they're a whole other entity.
Yeah, that totally makes sense. I think that part of my question though is, so Norma, you say that, you know, you have these 3 openings, no one's taking them. What is preventing them from taking them? Is it that we don't have enough people with degrees? Is that the job isn't offering enough benefits or enough pay, or the time? Like what is keeping people from taking?
Yes, yes, and yes. I can tell you that last month, 100 mental health counselors left the field in the region, because they're exhausted. They're mentally, physically exhausted from the job. Second, we're not getting enough people, you know, with Walla Walla University here, we would think that we would have an influx of it, but we don't. We just really don't have enough moving through the system. Plus for teenagers, that's pediatric. A lot of people don't want to work with youth because of it's just more difficult. Some prefer marriage or, you know, other types of care. They don't necessarily want pediatric. And then the pay is low. If in private practice, you can make $140 a session, but then you work for an organization like a nonprofit or this county, you're making $40 an hour max. It's just a terrible, terrible system in America, since we don't have a national or even a state focus on it.
And to compound everything that's happening right now with social isolation as a result of COVID and everything that's occurring is compounding everything that's happening, which is making the calls go up and the stress. And we've had record suicides in Walla Walla County.
I know.
It's a very tough time for everybody.
So I'm just looking, I just did a quick Google, and this came from the Seattle Times, October 1st of this year. It says approximately 37% of state residents live in a region that has a shortage of mental health providers. Only 12% live in an area where they could expect their mental health needs to be met. So it's kind of shocking, I haven't read it, but that is consistent with my observations.
You know, right now for teen mental health, there's a 6-month waiting list in Walla Walla County. And that, you know, at the health center, I know at Wahai, I have a 17-person wait list. At Pi High, we're now at 23-person wait list, trying to get in to talk to some of our counselors. It's Lincoln High School is the only one we're able to accommodate because they're a much smaller school. But the other ones we're not able to do. It's a crisis, for lack of better words. It's a crisis in care. I don't know if Troy's finished, and I don't want to take up too much more of your time, but I just want everybody to start thinking about, now we know what Troy and Reed talked about. Now, how can this committee go out and educate the public about what we're combating, or what the police are combating, or what the legal systems restricting? You know, what can this committee do now that we know what's going on? What's the next step for this committee? And, you know, maybe something for Nadine and the rest of the committee to talk about, but what steps now that you know, what are you going to do with the knowledge? Okay, I'm off my soapbox.
Thank you, Norma. Yeah,
Yes,
I
ma'am.
think that was good.
I just want to say I have to go to another meeting. I apologize. Is there any other questions for me before you answered the mayor's really tough question?
Thank you, Troy.
Is there
Thank
going to
you
be
so much.
wine at the meeting? That's my question. If so, have a glass of wine, not driving.
Good night, Troy.
Okay, next on our agenda is, I can't read. Oh, another presentation from Mr. Rizzatello.
Okay, the next two are fairly quick. This one's informational. The other one coming up will be for you to look at and get back any comments or suggestions to me. With this first one, though, I just want to make you aware because this helps with the digital divide and making sure that everyone has good access to internet. Is that the city did obtain an AARP Community Challenge grant to get some free 5G Wi-Fi available at some of our key parks and municipal campus. So roughly around $18,000 to get the 5G fiber and everything out there. We put out the service provider, RSQ. There was only one provider who bid on it, which was Pocket iNet. Pocket iNet right now is running the appropriate infrastructure to said facilities, and it'll be live by the end of the month, but there will be free 5G Wi-Fi at Lions Park. So they'll cover the entirety of that. Kiwanis Park, which is out adjacent to Davis Elementary School. Veterans Park. Veterans Park is a public park over in the Haven Homes Homestead subdivision, just south of 4th between Dones and Homestead. So that'll have it. And then also the municipal campus. So that's just an FYI, that'll be live and ready to go by the end of the month. Any questions?
That's exciting, especially for Lions Park. And also, what is it? Is the
Oh, you
city
broke
promoting
up.
it like on the how? How can how can we help promote?
I would say as far as the promotion of it, I mean, it's going to be through our monthly newsletter, so people are aware of it. As a condition of said grant, we need to be putting the signs out that there is free Wi-Fi available. So there will be signs constructed at said sites, both in English and Spanish. That was part of the grant submittal that we all wrote here. And then also, as soon as it's live, we'll put it up on the website and on social media, and then the reader board out in front of City Hall. So through those methods, and then also the state of Washington has a public Wi-Fi finder. So once it's live, we can submit it to that. And that website's really neat because you can essentially type in your address, zip code, where you're at currently, and it'll tell you where the nearest free 5G Wi-Fi location is at. So those will be the methods to get the word out once they're all live.
Thank you.
Mike, I think this is pretty cool. Thanks for doing that. A couple of questions. One of them that maybe pertains more to the diversity and inclusion is just usually when you go to a public place like this, you have to select that I approve, these conditions. Are we translating those conditions? Is there kind of, is the messaging, I guess, going to be in Spanish?
Yeah.
Awesome.
Yeah, because I actually instructed Pocket iNet to do the splash screens in English, Spanish, Italian, and Russian.
Perfect. I love it. Now, the follow-up question is, does the Wi-Fi have hours, or is this 24/7?
We have the ability to program it how we want. That's something I'd be very interested in this getting the feel from this commission, what do you think would be best? Because I've heard a variety of opinions on this one. There's
Yeah.
some that think 24 hours is good, but then there's others thinking that that's gonna essentially encourage folks to be in the parks after hours and stuff, and think that maybe it should have more reasonable hours, like 6 in the morning to 10 p.m. or something. So I would throw that question out to this body if you have a feel one way or another, because it's very easy to program that as such.
So I think it's a discussion that everybody should have, but I would make a suggestion that it match the bathroom hours. Just because we did a project similar to this in my church in California, and we found that to be a big obstacle, where people would come into the parking lot and then not have a place to go, and then would just, yeah. So it was a problem. So matching the bathroom hours would be important, whether you extend the bathroom hours or you just keep the bathroom hours for the Wi-Fi hours.
Okay.
I agree with that. I think that that's a reasonable amount of time. And I do see quite a few people who utilize the park for that reason. And I think that makes sense.
This is Kaylin. I think that while 24 hours, I can definitely see the issues with that. We should be offering kind of late night, early morning kind of options. Again, like, I'm very student focused, and a lot of my kids are submitting work at midnight or 1 a.m. Because they have responsibilities, whether that be in the household or jobs or whatnot. And so if they have access to that until midnight or 1 a.m., that might be nice. Or maybe different parks have different hours.
What time do our parks close?
Per the code, they close at 10 p.m.
So having access after 10 p.m., I suppose that it can be that they sit in the parking lot and access it and not really go into the park, but we want to make sure we don't want to put them in a situation where they might be violating our times, in the park. So we want to make sure that we are clear about that, because the last thing we want is for us to go kick somebody out of the park when they're just trying to do their homework, because they don't realize they're not supposed to be in the park.
And I mean, honestly, it might be the things where we program the sites for different hours. Because, like, for instance, I would say the safety element of the 3 parks is very safe, because those 3 parks have those security cameras in them. So, I mean, if we made the decision just to maybe kick the park hours out till even midnight or so, I mean, we do have security systems out there. So, I mean, it really wasn't like it was before when that original code was written.
Good. Sounds good. I like it. I'm thrilled with this opportunity for our community.
Okay, if there's no questions, we can go to the last item here. And this one is more for something for you all to ponder. So right now I'm working with Walla Walla Valley Blue Zones. And Lisa, if you could click on the spreadsheet specifically. So we're trying to develop the first ever citywide Americans with Disabilities Act transition plan, and there is a steering committee with community members essentially evaluating this. And what we're trying to do is I'm sure you all know, the city definitely has a backlog of areas where there's either sidewalk gaps or areas where the sidewalk ramps that do exist don't meet ADA and so on and so forth. So Walla Valley Blue Zones and our engineering intern are working on a way to essentially assign numerical values to projects, so that way we can come up with a fair essentially rubric list to prioritize projects. So I would just ask this committee to please look at this rubric, because you can see various metrics that are proposed. Again, this project is going to take a long time, so we'll be able to discuss this at the next meeting. But I am, if you have any suggestions, comments, areas for improvements with these proposed metrics, please let me know.
Mike, I just wanted to let folks know that I do sit on that steering committee. I appreciate it. I think I got the invite because of my position here. And so I do sit there and kind of was helping with these topics. And it's a great group of folks who have, you know, all kinds of needs and insight. And so, yeah, I agree. I think that taking a look at this would be helpful. And we meet, I don't remember when we next meet, but Mike would be a good person to provide any feedback to, so that we can get that to the next meeting.
Yep.
Are there any other questions about the ADA transition plan? No? Thank you, Mike.
Indeed, I forgot, I was going to mention one more thing for the Wi-Fi. You know, just one suggestion, Mike, would be to evaluate if it's mostly students needing the Wi-Fi. I don't know, you know, who's using it, but we've talked a lot about students using it. You know, maybe that space, the meeting space that's there, maybe that's opened up, you know, once a week or something like that. I think that might be nice to have an actual space rather than doing it in their car or in the parking lot. But just an idea.
Yep, we can definitely have those discussions with the Lions Club.
That sounds good. Mike is laughing because I'm president of the Lions Club, and so that would be definitely a conversation I would welcome to see how the logistics could be in terms of who opens it and when, if that's of interest.
Yep.
I think we could maybe match it with some of the tutoring that's happening from some of the college students, university students to public high school or whatever. We can talk about it, Nadine, but
yeah,
I think there might be some options.
That sounds good. I like that. Anything else for Mike Rizzatello this evening? No? Okay. Are we on the next piece?
That was it for the
closing
regular agenda.
Okay.
So just if anyone, and I believe I know that Member Pike does have something for the good of the order. So.
Okay, we're at the good of the order. So yes, Member Pike, if you're ready.
Awesome, thank you. I have two things for the good of the order. The first one is I would like to propose a meeting time change. After talking to Member Pons, there is no way with his schedule as his position at the middle school that he can make it at 4:30. And so we discussed maybe meeting at like 7 to 8 instead, same days. But I don't know, is that a motion, Lisa?
Or is it a discussion, maybe?
It's a discussion, but if the four of you that are here, you are a quorum. If you all agree to do that, and I'm assuming Member Pons already is in favor of that, then yes, it would take a motion to enact it.
Take a motion. Okay. I would like to get what other folks are thinking. Is 4:30 not working for you also? And what would be a better time? Ruben?
Honestly, for me personally, having two young kids and working 8 to 5, that's really late for me. It's dinner time, and I wouldn't mind doing it earlier, but doing it later, I think conflicts with me, and so for me, I think it would be harder doing, and it ends up being more than an hour and a half, 2 hours, so it's not like an hour meeting. So for me, it's a no.
Ruben, you said earlier, is there a time earlier that would work for you that's later than 4:30?
And like I mentioned, 3, we can do 3. I don't mind, during even if it's working hours, 3 o'clock. I know like he works at a school, so I'm not sure if 3 works for everyone, 3 to 5 or 3:30 or
What was your understanding, Kaylin? Was it like 7 because there was some time that needed to be had after the 3 o'clock dismissal, or?
Yeah, so what ends up happening is for both Donald and myself, we end up getting scheduled to watch basketball games and supervise those things. Or we have late parent meetings because we have to wait for parents to get out of work if there's a disciplinary issue, things like that. And so usually we can't like guarantee we're going to be free until probably about 6. I have a lot more flexibility than he does since he's the dean of students. And so later than 4:30 was what was asked for. But if not, he understands that as well.
Yeah, and to be honest with me as well, I think like 5 o'clock would be good for me. And I think that today's meeting ran a little long because the last meeting we didn't have quorum, and so that's why we're basically shoving 2 meetings into one this time. And when we do that, that's when we get longer meetings. We have more things to talk about. I don't know if there's any other time proposal. I like the 5 o'clock hour, but if it's not going to work for anybody, then I don't want to have it.
Lisa, not to put more on your plate, is there a way that maybe we can send out a survey? Because I know that not only are we missing Pons, but we're missing another member as well.
Yeah. I mean, I could add that I have access to a doodle poll, so I mean, I could send out a doodle and then we could see which times like work best for the most.
Do morning times work for anyone?
You're teaching, right? My assumption is you're teaching, Kaylin.
Yeah, and honestly, for those of you who don't work with youth, kids are not emotionally and maturity level where they are age-wise. And so we end up having more disciplines in a day than we used to have in a week. And so days during the school day is extremely unpredictable on where we're going to be and what we're going to be doing and if we're going to have time, unfortunately. We could look at doing a before school option, but that ends up being pretty early for people.
What about Mr. Lopez?
I can be flexible. I try to protect the evenings because I've got 4 little boys that like it when I tuck them in. If I miss one night, I hear about it for a while, but I do have quite a few nightly meetings because that's when students are just waking up. So like I said, it's once a quarter. So for me, it's really not a big deal. I can flex it as long as it's on my calendar.
Okay, so maybe we'll send out a doodle poll with options from, I don't know, from 5, 6, or 7.
That sounds good to me. What do you think about that?
That sounds great, and I will let Hans know that that is the plan, and he will respond within the next 3 to 5 business days.
Okay,
Thank you so much. Was there anything else for the good of the order?
I did have a second thing, and this I think is more specifically for the city, for Mike. With holidays coming up, what are things that we are doing? And maybe this is easier for you to think about and send out an email, but to be inclusive of all cultures, all traditions that we have represented in our area. Having just a Christmas tree or something like that can be really off-putting to people who don't celebrate Christmas. And so I'm wondering, what is the city doing to be inclusive as this holiday season approaches?
I can send out an email on that to this board.
Awesome. Thank you so much.
Okay.
Thank you so much. No, that's a great opportunity for this board. I appreciate you bringing that up, Kaylin. Okay. Was there anything else for the good of the order? Okay. What time is it? Do we look for a motion to adjourn the meeting? Would anybody like to move to adjourn the meeting?
This is David. I move to adjourn the meeting.
Okay. Is there a second?
This is Ruben, second, end the meeting.
Okay. First and second. All in favor of adjourning, say aye.
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 Opposed? Okay, we are adjourned. Thank you so much for a very productive meeting today.
Thank you. Good seeing everyone.